Good afternoon, Your Honors. Good afternoon, Mr. President. It is my honor and privilege to appear before you today on behalf of 17 human rights organizations based in Afghanistan. These are organizations that have spent the last 2 decades enduring conflict and violence to service war victims and human rights victims in Afghanistan. These are organizations that are truly on the front lines, having helped thousands of Afghans over the past years, and in the past 3 months alone, have surveyed and interviewed hundreds of Afghans so that you can benefit from direct voices on the ground in Afghanistan. Based on our observations and our communications with victims, fundamentally what victims want is to be taken seriously, to have their voices heard, to be genuinely understood, and to know that their opinions and hopes will not be sacrificed, marginalized, or abused for political purposes. Your Honors, it is our contention that the pretrial chamber failed in all of these respects, and we believe that the outcry that you hear today, including questions concerning this court's legitimacy, is a result of those failures. Our submissions today and on Friday are intended to aid you in remedying those mistakes. Your Honors, in relation to your Group A questions, we agree with our colleagues that victims have standing to enforce their rights during the pre-investigative stage. But where we differ from our colleagues is the scope of that standing. We submit that the standing victims enjoy is coextensive or coterminous with the rights or obligations victims enjoy under the statute or the court's legal text, which under Article 15.3 is to make representations before any Article 53 decision. Here, our submission is that right was denied, and that it is essential for this chamber to address that denial, regardless, but particularly if this chamber chooses to deny victims a right to appeal decisions made under Article 53. Absent appellant guidance on Article 15.3, which is currently lacking, Your Honors, future chambers of this court risk alienating victims the same way pretrial chamber 2 did in this situation. Your Honors, as you well know, the statute guarantees victims the right to make representations under Article 15.3. Those representations are also necessary for any Article 53.1c inquiry, which explicitly requires an assessment as to the victim's interests. And there is simply no substitute for that assessment than the opinion of the victims themselves. The right to make representations, however, has to be effectively enabled. This means that victims must be notified and have sufficient information concerning their rights and be given a reasonable opportunity to make representations considering their specific circumstances. Because without these requirements, the process of soliciting the opinion of victims would be reduced to a formalistic exercise that gives the appearance, but not the reality, of meaningful victim input. It is, Your Honors, reasonable, timely, and accurate notice in particular that allows victims to assert their rights and facilitates their participation. It is the door through which all other rights for victims are afforded. The fact that representations must be effectively enabled is supported by statements by the Assembly of State Parties, international human rights instruments, and national laws concerning victim participation, the authorities of which, Your Honors, I point to in pages 3 to 9 of our table of authorities, which you can find in tab 1 of the binder that we have provided you. In this case, however, pretrial chamber 2 failed to effectively enable victim representations, especially by Afghan women and Afghan children. And the evidence for that is summarized on pages 14 to 16 of our table of authorities, which reference sworn declarations by leaders of civil society organizations who worked with the registry in the victim outreach process and who are eyewitnesses to the victim representation process. As those victims detail, the outreach process in this case was flawed to such an extent as to bring into question the sincerity of the pretrial chamber's invitation to victims. For example, victim input was solicited via an online intake process, even though only 15% of Afghans have internet access and only approximately 30% are literate. The representation period was only open in the months of December and January, even though those are the coldest and least traversable months in Afghanistan. The registry had no presence in Afghanistan and had no outreach or public information activities in the country to try to reach victims directly. The pretrial chamber failed to order a mass media campaign using Pashto or Dari-speaking radio or television, the primary means through which Afghans obtain information. And the pretrial chamber failed to provide victims sufficient time. It provided victims 2 months, a period wholly insufficient for a country where information about the ICC was scarce, where the court lacks a physical presence, where ongoing conflict hampers access to many of the areas, where many people are illiterate and do not have internet access or stable electricity, and where, Your Honors, for very good reason, the population has learned to be careful about sharing information that may subject them to harm. These errors had a clear and discernible impact on the ability of Afghan victims to make representations. In a country of over 35 million people suffering 4 decades of war, where 69% of the population are believed to be victims of war-related violence, only 699 victim representations were received by the registry, only 165 from individuals. And for that, Your Honors, I refer you to paragraph 23 of the registry's report, annexed to filing 29. But equally grave is the fact that the pretrial chamber took no measure to enable representations by women or children who are victims of crimes, as required under international human rights law, the authorities of which you can find on pages 10 to 14 of our table of authorities. For example, with regards to child victims, of which there are hundreds of thousands in Afghanistan, the pretrial chamber and the registry failed to provide child-sensitive materials and information services. Further, no efforts were made by the pretrial chamber or the registry to target or accommodate Afghan women and girls who are faced with systematic violence and human rights violations, including sexual violence, abuse, and trauma. As Your Honors are aware, many Afghan women, female victims, feel an acute sense of stigma and shame in sharing their stories. They often also face the additional hurdle of having to seek permission to leave home or needing to be accompanied by a male relative. Yet nothing was done.
You have 2 minutes left.
Thank you very much. Yet nothing was done to ensure that these women were properly informed of proceedings and how they could participate. And instead, all efforts and all appeals by leading women's rights groups in Afghanistan for more time to ensure that women were properly represented were ignored. And Your Honors, in support of this, I draw your attention to tab 7 of your binders, which contains a declaration by one of Afghanistan's leading women's rights figures, as well as copies of her communications with the registry on precisely this issue. Your Honors, this deliberate disregard for the situation of women and children had a considerable impact. Only 10 representations were made on or behalf of women, and only 9 representations were made on or behalf of children. And I refer you to pages 10 to 12 of the registry's report, annexed to filing 29. And when the pretrial chamber was informed of these massive deficiencies, no corrective action was taken in the over 420 days between the end of the representation period and the chamber's Article 53 decision. Your Honors, in his separate opinion, Judge Mendua claimed the ICC to be a victim-centered court. In our opinion, however, the errors that we have just described, especially when you consider them collectively, demonstrate that the pretrial chamber did not sincerely or genuinely solicit the opinion of Afghan victims. And the victims now turn to you to right that course. Thank you for your time.